problem. They've come to me in a time of need when really no one else is there for them. They've been abandoned by a lot of their friends, their family perhaps, and perhaps maybe they've never really had a friend at all to stand beside them, to stand up for them, and to take their position. And so when I talk to them, I see just a person across my desk who really is a pretty good guy or a pretty good woman, and I don't really have a problem with that because I'm just helping them out with a problem. Now, as to the second part of your question, how can you defend a person who you know is guilty? I guess that's the basis of the question. And I was talking it over with a friend tonight, and he actually said something in which I think hits the nail on the head. Sometimes good people do bad things. And when they do those bad things, that's the time when you really they need someone who will take their position, who will fight for them. And also, saying someone's guilty of a crime or has done something wrong that you know that they're technically guilty may not mean that there's any real moral law that they've broken. The government passes all kinds of laws, some that people agree with and some that people do not agree with. The statute books is a huge statute book with every law imaginable that no one could possibly know. And frankly, I think that if most people knew what the laws were, a lot of people wouldn't vote for them, wouldn't agree with them, maybe even the majority of people. So when you say someone's guilty, sometimes it might not make any difference because what they're guilty of may not really be something that you find morally reprehensible or even morally wrong.
Sometimes do you have a situation where what they're charged with is not what they did?
Oh, absolutely. Sometimes you have a situation, and it's really not that uncommon. It's nearly as uncommon as people think, that they're charged with something and they really didn't do anything. They're factually innocent, but the government, with all their power and all their resources, once they make a decision, oftentimes I'm sure Mr. Taylor will want to respond, but once they make a decision, tend to go with that decision no matter what. They look at that as they take it personally. They internalize it, and they want to win, and they'll let innocent people go forward in the process. And a lot of times innocent people get convicted of horrible crimes. In Illinois recently, several people, I think the count now is up to 30, people that were on death row, convicted of first-degree murder, and given the worst punishment possible, a punishment that you cannot possibly go back on, were found to be factually innocent through DNA testing done by a group led by Barry Scheck up there, who some people know from OJ fame, who started the Innocence Project. And that's just in that one state. And that's only people who could be proven innocent with DNA testing. So there's a lot of folks out there who the government is convicting who didn't do anything.
Rich Brown, now you practice civil law.
Yes, Russ.
And what we were talking about was criminal law. Can you tell us the difference between the two?
Yes, and a lot of people do have some confusion about the two areas of practice. A civil litigator, to sum it up, basically takes disputes between usually private individuals, sometimes a private individual versus a government, if they've alleged the government has done something wrong, either breached a contract or is negligent in some way. But for the most part, civil litigation involves private disputes between either individuals and the government. And most of the time it's involving money. Contracts usually involve money, the transfer of property involving money, or those types of disputes. And so we handle a lot of those types of disputes involving breach of contract, general civil litigation, as well as corporate disputes between businesses. Sometimes businesses themselves have disputes, and that's civil litigation. What criminal lawyers or attorneys do for accused criminals, like Mr. Taylor here to my left, who is a prosecutor, the state prosecutes, the job is to prosecute criminals, and defense lawyers like Mr. Guttridge here to my right defend those individuals who are accused by crimes and either work out a plea bargain or take those cases to trial. Usually, and for the most part, almost always, there is not a claim by a criminal defendant for money damages. Sometimes the state would request that restitution be paid to victims of crimes, but that is a very different matter than a civil dispute between parties. So a civil lawyer handles basically private disputes. Criminal lawyers, both prosecutors and defense attorneys, as well as public defenders, handle matters within the state's jurisdiction which involve crimes which are violations of criminal statutes.
Now, do you go into different courts as a civil attorney?
With regard to civil disputes, yes. In our county, the jurisdictional limit for a circuit court, which is the highest court on the state level, is you have to have a minimum dispute of $15,000, which means that the amount of dispute between the parties has to be at least $15,000. There are judges that only handle those matters which are in the circuit court jurisdiction. County court handles anything up until $15,000, and judges in our county handle small claims which are included in that amount and are usually and always must be, below $15,000 in jurisdictional limits. But it is handled through the same courthouse, but most of the time judges who are designated as circuit judges only handle those things which are designated as circuit court cases, and county court judges handle those things which are designated as county court or small claims types cases.
Okay. Ed Taylor, who do you work for, and when the state attorney, you're an assistant state attorney, right?
Correct.
Who do you work for, and how does the state attorney's office decide which cases to prosecute?
Russ, I work for Bruce Colton, who is your elected state attorney for the 19th Judicial Circuit. That encompasses Indian River County, St. Lucie County, Martin County, and Okeechobee County. Mr. Colton is elected, he's a constitutional officer. Our job description is designated by statute, so our duties are clear. How do we decide who we prosecute?
Which cases to prosecute?
Which cases do we prosecute? We decide based upon the facts and the evidence. Unlike our colleagues on the other end of the bar, we do not have a physical client per se. We don't have a duty to this client. I know Mr. Guttridge mentioned his clients. He has a duty to represent that client with zealous advocacy within the law. We have a duty to pursue justice. That is our duty, and that is our foremost duty. When we evaluate a case as prosecutors, we look at the facts, and cases are brought to us generally by police officers, and usually an arrest has been made, and we evaluate the facts to determine if that case can be proven to a jury, at least in our estimation, beyond and to the exclusion of all reasonable doubt. Now, there's a misconception regarding the distinction between an arrest and what we do as far as filing charges. A police officer needs only to have probable cause to make an arrest, and a probable cause is a relatively low burden of proof. It basically means that a crime has been committed, and a reasonable person could conclude that the person who's being arrested has committed that crime. Our standard is much higher, and we have a moral obligation, as well as we have taken an oath to enforce the laws of the state of Florida, whether or not we personally agree or disagree with them. There are many laws in Florida. The legislature creates the laws. We have nothing to do with that. We hold what's called a state attorney hearing. Especially in a felony case, before criminal charges are filed, when I file felony charges, I sign what's called an information under oath, stating that I am basing my decision on sworn testimony. And this is sworn testimony not only from the police officer who made the arrest, but we also call in witnesses who can prove or disprove the crime. And we talk to everybody so that we can have an informed opinion as to what we are doing before we do it. So we don't take that decision lightly. In fact, it's probably one of the most serious decisions we have as to which cases do we prosecute. Do we charge someone with a felony? It's a very serious decision, and we don't take it lightly. And we do review all the available evidence before making that decision. Sometimes things happen between the filing decision and the date of trial, that may change our position. A lot of times the defense will produce witnesses that have an impact on our thought process, and that can affect how we go forward with a specific case. But basically, I would say it's a very time-consuming, a very selective, thought-provoking process.
Then would it be correct to say that sometimes a case will come to you, and when you review it and after you've talked to the witnesses, you either change the charge that the officer may have put down, or you drop the case, or send it someplace else?
That happens often, Russ. We look at the case differently than law enforcement does. We work closely with law enforcement. However, when we're looking at the case, we're looking beyond the probable cause standard. We're looking at the proof beyond a reasonable doubt standard, and we're looking at putting our name on a charging document charging a person with a felony. There are many times where, after reviewing all the evidence, we decide, prior to initiating formal proceedings, that the facts just aren't there. The evidence just is not there. Or there may be a problem with the evidence. We may foresee a problem that would prohibit the evidence into admission into court. So yes, there are many times where a person is arrested on a crime where charges are not pursued, or charges are pursued as misdemeanor or lesser felonies.
Mr. Green, we've got a question that got called in. I wonder, would you be interested in answering something along the lines of a car accident? Anybody else?
That's really not my expertise.
All right, well, let me ask you another question. Regarding a family or a divorce court case, how long does it take to get a divorce? What's the short time and what's the long time?
That is the question that is always and invariably asked by every client. The short time would be if the parties can basically get together, reach an agreement, have the attorneys for both sides, because actually, unless they're going pro se, that is without lawyers, if one side has an attorney, it's probably a good idea for the other side to have an attorney. If you put together an agreement, it can be done as rapidly as within a month. If they want to argue about the salt and pepper shakers, if they want to fight about every little issue, it's taken 6 months, a year. I mean, we have a case that's gone on, it seems interminably. It's taken a year and a half. But those are the bloody battles that hopefully the people don't want to see.
Well, say someone is getting a divorce and they come to the time when the judge says, okay, you're divorced. But they are not happy with the way things were divided, say. What happens then? What's available?
In a property division, is this where they had a trial and the judge
Yes.
made the determination?
Yes.
If they're unhappy that way, appeal is their only option.
So they go to another court.
They would have to go to a higher court, an appellate court, but the appellate court really only reviews whether the judge applied the law correctly. When it comes to dividing the property, generally the court makes factual determinations as to what the value of property is and how it should be divided. When the court does that, it's rarely, if ever, will the court get overturned on the property division issue.
Well, is it better for people to reach an agreement between themselves or to let the judge do it?
Well, when you reach your own agreement, be it through your lawyers or now we have mediation, a process where prior to trial we have certified Supreme Court mediators who hear these, get the parties together and try and get the parties to put together their own deal. Without fail, if they put together a mediated agreement, they're not back in court every year arguing about this, arguing about that, arguing about visitation, arguing about child support. Generally, if you can put together your own deal, it's your deal. It's not done by someone that really doesn't know the case as well as you, like the judge who's going to hear it in a half a day or a day, when you might have been married 5, 10, 15, 20 years, and you have all these issues to deal with. If you put together your own deal or you have a mediated agreement, generally you're not back in court. It works out much better that way.
Mr. Brown, we have a call in. I was in a car wreck in 1998, which wasn't my fault, and I was injured. How long do I have to sue?
Russ, in Florida, the, excuse me, the statute of limitations, if the intent of the question is, can the person sue the other driver for negligence, which would be the cause of action if the person is injured, you have 4 years from the date of accident to initiate a lawsuit.
Okay. Mr. Guttridge, we have a question. If I get pulled over, and I take it, we're talking driving a car, stopped by the police. If I get pulled over and have been drinking, should I blow or not, and what are the consequences?
Well, I'm assuming they mean should I take the breathalyzer?
Right.
And if you're not driving, obviously you don't have a problem. Basically, the basic answer is no, and for this reason. The ramifications of not taking the breathalyzer originally are this. The Department of Motor Vehicles will suspend your license for 1 year. Now, you can challenge that, but those challenges are rather difficult. Now, if you do take the breathalyzer and you blow over the limit, they will suspend your license for 6 months. So they're going to suspend your license anyway. Now, you won't be able to get a hardship if you refuse for a period of 90 days, which is what the procedure that the Department of Motor Vehicles is using. They say you can't get any kind of license for 9 days, not even one to go to work. If you take the breathalyzer, you can then get it in 30 days. You only have to go 30 days when there is not a license at all available for you. But the problem with the breathalyzer is this. It measures the alcohol that is in your breath. And that really has no effect, no correlation at all. And I think even my experience has been even the prosecutors have said under oath on the stand, and even the experts that they have called as witnesses have said that there's really not a correlation. You can't tell whether someone is impaired from the breath machine, only from how much alcohol is in their blood. And the breathalyzer doesn't measure that. And frankly, it's extremely inaccurate measuring that. I very recently in our bar association meeting took the breathalyzer. I dosed myself with alcohol, taking several drinks over a period of time, and I blew into the breathalyzer. The first breathalyzer reading was a .193, which would make me extremely intoxicated, what people might typically think is falling down drunk. The second reading was a .025, which would really relate to about maybe 1 beer. And the third reading was a .075. All of these readings showed up as valid on the same card. They were all within 6 minutes. And I guess the point is that you can't possibly tell what effect the breathalyzer, what those results mean. They can be all over the place. The machine's extremely unreliable. And if you take it, you're just giving the prosecutor and the police an opportunity to possibly convict you of a crime when you've really done nothing wrong, nothing that is, you maybe had 1 beer or a glass of wine with dinner.
So in the test that you performed, that's a big difference, right?
Oh, absolutely. That's completely off the scales. One being absolutely, if it was a blood alcohol reading, which actually impairs your brain, which is what we really care about, whether someone's impaired and can't function a car, that would be really falling down. You wouldn't be able to perform any normal activities, at least a normal person wouldn't. And an 025, which was the low end, which was the second reading, you would be able to do almost anything. You probably wouldn't even notice that a person was impaired by alcohol at all. And in fact, they probably wouldn't be impaired. They would have 1 beer or 1 glass of wine with dinner.
Well, could someone blow a .19 and 6 minutes later their body burns up that much alcohol and blow a .025?
Absolutely not. If you were measuring blood alcohol level, that would it would be physiologically impossible to do that. It would take several hours, and I mean, if I were to calculate it, it would probably take 5 or 6 hours to burn off that much alcohol to get you to that point. And I guess the lesson to be learned is it's an inaccurate machine that can either read you being over the limit legally, or not over the limit, and it's based on no real scientific proof, no scientific validity that relates to whether you were impaired to operate a motor vehicle.
Well, is it an inaccurate machine, or is it skill on the part of the person blowing into the machine that can cause, maybe not skill, but the way they blow in that could cause that kind of difference in the results?
Well, I don't really know. I think maybe a little bit of both, but the fact that it would take those readings in and of itself shows its unreliability. There was no error message when I did it. There was no error message. And, you know, it's not really an aberration. I have seen readings that are all over the place that have come up with either inaccurate readings or readings that you simply knew weren't true, or you've talked to your client and you simply believe them when they tell you what they had to drink, and that does not correlate to what their blood alcohol reading should be.
Okay. Mr. Taylor, do you do the DUI or drunk driving type cases?
I have prosecuted probably 1,000, I don't know, hundreds of DUI cases in the 12 years I've been at the state attorney's office. Most of our DUIs fall in the misdemeanor category, and in the years I was doing that, there were just literally hundreds of DUIs that came before the court. The breathalyzer is really called an intoxilizer machine. In the 12 years I've been doing this, I've never seen such disparity as Mr. Guttridge has just mentioned. And there is a built-in safety mechanism, not with the machine, but with the code of evidence, FDLE requirements stating that if there's a certain disparity between the two tests, it's deemed unreliable. So if there is that type of disparity, you're going to deem it unreliable, and it probably wouldn't even be admissible into court. The machine has been accurate when used properly. When the person blows into it properly, they follow the instructions of the intoxilizer operator. The machine is properly maintained and is deemed to be a very reliable instrument for testing blood alcohol. Now, a person can have a high blood alcohol level and look not to be impaired by alcohol. That's why we have a crime called dubal, driving with a unlawful blood alcohol level, D-U-B-A-L, dubal, and that's anything above a .08 there's a presumption, and the judge will instruct the jury that a person who has a .08 or above is presumed to be under the influence of alcohol when affected to the extent that his normal faculties are impaired. So the person doesn't necessarily have to be impaired. There's a legal presumption that at that point, anyone is impaired at a .08. The breath test is deemed reliable. I think the question you asked Mr. Guttridge was, what advice would you give? Certainly a person who's had 2 beers should blow into the machine. A person who's had 10, he's going to have a bad reading, because why? It's going to be evidence that's used against him. And the state attorney's office, I mean, when I was prosecuting these cases, it was a very strong argument to make to a jury. Why doesn't this person want you to know what his blood alcohol level is? Why is he hiding that from you, ladies and gentlemen of the jury? And it was, for me anyway, a pretty effective argument. I certainly can't give anybody advice as to what to do, but the blood alcohol machine, the intoxilizer, is a very reliable and accurate instrument if done properly on both ends.
Mm-hmm. About how many cases, of all cases, does the state attorney's office handle in a given year?
Well, I anticipated that question. In fact, I called the clerk's office today just to see how many cases we prosecuted last year from beginning to end. And we handled, and I say we have 4 felony prosecutors in the state attorney's office in Vero Beach, 2 misdemeanor prosecutors, a misdemeanor supervisor, a juvenile prosecutor, and Lynn Park, who is in charge of the office. We prosecuted 4,300 misdemeanor cases last year. 700 of those were criminal DUI cases in the misdemeanor court. Mm-hmm. Our felony division prosecuted a little bit over 1,800 felony cases from beginning to end. We have 4 felony prosecutors, so you can see that each prosecutor handled about 450 cases. Now, this does not include numerous violations of probation. Almost every person that's placed on probation, I shouldn't say it that way, but many people who are placed on probation do end up violating probation. We end up having hearings on that, and that number does not include appellate proceedings that we also have to engage in, ineffective assistance of counsel, motions for a new trial, that type of thing. So there's a lot of activity associated with the state attorney's office.
Mr. Green, we have 2 divorce questions. One says, if my husband resides in New York, can I adjust my child support here in Florida?
Yes, you can do that. There's a procedure. There's interstate compacts throughout the United States, and you can go to Department of Revenue here, file your papers, and they'll have a proceeding in New York to determine what the income level is of the spouse in New York. They'll compare it with the spouse in Florida, and generally most states now have guidelines as far as child support is concerned, and they can adjust it.
Okay. So they could file here in Florida, ask the court to adjust it?
The New York court would then take the testimony, correct?
Okay. Next question. I quit-claimed my home to my ex-husband in my divorce, but now the home is being foreclosed on. What are my options? I am being sued because I still owe on the mortgage.
That comes up quite frequently, Russ. What happens is the court, when you file your case, gets jurisdiction of the parties, the husband and wife, and all of their property. However, the court does not get jurisdiction over the bank or anyone holding the mortgage. So even though one spouse will deed any right, title, and interest that spouse has to the other spouse, either pursuant to a court order or through their agreement, it does not relieve either party from the mortgage note and the mortgage and lien against the property. So if what the spouse who owns the property now, or the spouse that doesn't own the property, either one, can, if the court order or the agreement makes the non-owning spouse or the owning spouse pay for the property, and they stop paying for the mortgage, you could maybe enforce it by contempt, or when you're sued by the mortgage company, you can cross-claim against the spouse that hasn't been paying.
So if in this case the other party had agreed to take the house and pay the mortgage but stopped doing it, this person who gave up their right to the home could sue them?
Well, they'll both get sued in a foreclosure proceeding in all likelihood, and then there could be a cross-claim there, or depending on what the wording of the order or their agreement is, they could go back into court and have the divorce court enforce or compel the one spouse to pay.
Make the mortgage payments?
Right.
Yeah. So that's a difficult area.
That's a difficult area.
Many times the people can't afford to, or a bank won't let them off the, can't afford to refinance.
In a lot of agreements, we try and have the non-owning, or have the owning spouse refinance and get the non-owning spouse off the mortgage, and that resolves the problem.
Okay. Mr. Brown, this is a call-in. A prominent talent agency has approached me with a contract for my child. What is the first step I should take before I sign the contract?
Talent agencies are regulated in the state of Florida by a talent agency statute. Creates certain restrictions and obligations on the talent agent, him or herself. With regard to the contract, it's always best, obviously, we recommend that it be reviewed by an attorney or someone capable of reviewing the contract. And I have done quite a bit of that type of work with regard to entertainment-related contracts. Talent agency contracts can be either very limited or very broad, depending on who you're dealing with. In that business, just like any other business, there are reputable talent agents and there are disreputable ones, and it's important also to check out the talent agent as much as possible. They are regulated in the state of Florida by the Department of Professional Regulation. I do believe it's possible to check out individual agents and or agencies through that process. So we do recommend that you have that contract reviewed by an attorney. that you're not signing away all of your rights, and that you understand what those rights are before you sign the contract, especially where a child is involved, because the court ultimately will hold the parent responsible for whatever decision they make with regard to that child. And depending on the age of the child, it could be a long-term commitment. So it's also very important to understand what you're engaging your child in and for what period of time. But we do recommend that especially when a child is involved, when they're not capable or may not understand what they're getting into, that the parents be fully informed before making that type of a decision.
So either the attorney or the parent could check on the talent agency itself?
Yes, it is. Again, it is regulated by the Department of Professional Regulation, and I'm not sure of the exact procedure, but there are ways through the state offices to check on individual agents if complaints have been filed against them, similar to attorneys and other professionals who are regulated by an agency within the state. You can check out whether or not those agents have been subject of a complaint, resolution of that complaint. Also, sometimes, depending on where the agency is located, you should check with the Better Business Bureau. They are regulated just like any other business. So that is very important, especially in that business, because again, just like in any other business, there are reputable agencies and some that are not so reputable. So it is very important that you have that information before making such an important decision.
Okay. Mr. Guttridge, if I am approached by a law enforcement officer investigating a crime, what should I do?
Well, I guess the first thing you have to decide is whether he's investigating you or he's investigating someone else. You know, if it's a family member, if it is someone that you don't like or you have you want to see them prosecuted. Certainly, if it's someone you want to see prosecuted and they're investigating a crime, you might want to cooperate with law enforcement. But short of that, you probably don't want to cooperate too much. Unfortunately, there are, for the most part, no rewards, no gifts for being cooperative or talking to the police. And they're very good at getting you to talk. They're trained investigators. The folks that go out from law enforcement that typically investigate crimes, they're detectives, are typically very sharp individuals. They're very charming at times. They will act like they're your friends, and they will try and build some sort of a case against you or a family member. Typically, they won't read your rights because they don't have an obligation to. Unless you're in custody. Most folks, people come in all the time and say, well, you know, they didn't read me my rights. Unfortunately, they don't have to read your rights in every situation, only when it is a custodial interrogation. And that means they have to have put you in custody, essentially arrested you, and then there's some nuances regarding whether that's really custody, but they basically have to arrest you, and you have to know that you're being arrested. If they just say, hey, come down and talk to me, they sit you in a room for 30 minutes, you may feel like you can't leave, that you're being forced to stay, that still probably doesn't qualify as a custodial interrogation, and they don't have to read you your Miranda rights at that point, and they will try and get you to make a statement that might not be in your own best interest, or that might not be in the interest of a family member. And if they're investigating someone else, they don't have any obligation whatsoever to read you your rights. Whenever you're approached by anyone who has an interest that is adverse to you, whether it's in a civil situation, you're buying a home and you're trying to negotiate a price, or really in any situation where you may not know what the law is, or someone may be trying to do something that is adverse against your interest, you should always call a lawyer. And that's what you should do, or at least ask for one. And in a criminal situation, when what is at stake is your liberty, and the government, who has endless number of lawyers and enormous resources that you may not have, you always want to have someone on your side at that point who understands the law and who will look out for your interests and tell you what you need to do and how you need to handle the situation. So the first thing you should do probably, if they approach you, before you even find out what it is, say, well, you can give me the questions, but I would like to consult with a lawyer before I and I talk to you.
Mr. Taylor.
Yes, sir.
We have a call-in question that's a little bit different from that, but I wanted to ask you something about this endless number of lawyers. Do you have an endless number of lawyers in the state attorney's office?
We could use about twice the number of lawyers that we have. Like I said before, we have 4 felony prosecutors, and of our 4 felony prosecutors, we each handled about 450 cases last year. That's about an average of 2 felonies from start to finish a day, in addition to our other duties. So certainly I don't think we have an endless, certainly doesn't seem endless when we're sitting in the office trying to cover all the workload that we have. So
well, what Mr. Guttridge may have also been talking about, aren't there federal prosecutors?
There are
federal
federal
courts?
prosecutors. They work for the U.S. Attorney.
Okay.
There is a U.S. Attorney's office in Fort Pierce. They prosecute violations of the federal law, of course, and we focus strictly on violations of the state law.
Okay. We have a telephone call. Excuse me, I'm going to have to go up. We've had 3 telephone calls, but this one... Yeah, here it is. What... A caller wants to know if a state attorney has a quota per year and wondered why so many cases, this is assuming this is true, we don't know if this is true or not, why so many cases are dropped after the person has been arrested and had to bond out of jail.
Quota, no.
No quota.
We're standing there in the batter's box taking whatever's thrown at us.
Right.
There's no quota whatsoever. We get assigned individual cases based upon our experience, and basically right now in the felony division we have 2 divisions, A through K and L through Z, alphabetically is how they're assigned. And the degree of the cases is based upon the experience of the attorney. I think I answered the second question already, and how come cases are dropped? We hold a state attorney hearing. We evaluate the evidence. If we don't have the evidence, we cannot in good faith proceed with the case. And that is our obligation as state attorneys. A person, I'm sure a person that is arrested on a charge, on probable cause, and that is the standard, wants to bond out as soon as possible. And if they bond out and the charges are then dropped after he bonds out, that's a contract he made with his bondsman. It had nothing to do with the state attorney's office. We have 21 days by the rules of criminal procedure between the date of arrest to file a charge, make a decision. We have a filing decision. We have to make a filing decision within 21 days of the date of arrest. Within that 21 days, we schedule a state attorney hearing and review the evidence and make a decision whether or not to charge. If the person bonds out between that time period, it's not something that we have any control over.
Here's another question. Mr. Green, you do some criminal work, don't you? All right. What is and Mr. Guttridge mentioned this topic, what is the status of one's right to remain silent? Do you still have the right to remain silent, and do the police have to read you your rights?
Well, there's 2 parts to that question.
Yes.
You always have the right to remain silent, period. You're smart if you do. That's the easy advice to give someone. You're under no obligation whatsoever to cooperate with the police. I mean, if they come out to you and want to start asking you questions, especially if you're the focus of an investigation, as soon as you say, I want a lawyer, that triggers, that kind of triggers everything. That causes the police, theoretically, to stop questioning you. To provide you with a lawyer, if you're in custody, they'll provide you with a lawyer, if you can't afford one. If you're in custody, they're supposed to read you your rights before you do say anything. If you're not in custody, as Bobby said, they'll come out, they're very skilled. They'll say, oh, well, why don't you just come down to the station and we can talk this over, or we have a couple things we want to talk over with you, or there's no, they can lie to you. There's no penalty for them lying to you in these investigations. They can come out and tell you, oh, we know this and we know that, and we already know that, such and such happened. We already know you may be involved, and they may or they may not know. If you ever feel the least bit that they're trying to investigate you for a crime, tell them you want a lawyer and close your mouth. That gets more people in trouble. They're wanting to talk, they're wanting to explain than anything in my 30 years of experience.
Okay, let me ask,
Can I add one thing to
Yes.
that? Being we are focusing on criminal law here, and I haven't discussed the
Good, a
right
lot
to
of
remain
questions.
silent.
Yeah.
Both Norman and Bobby have talked about when the person believes he or she is the focus of the criminal investigation. I do want to urge everyone, at least from my perspective as a prosecutor, to cooperate with the police in investigations, because there's nothing more frustrating than having a crime with a dozen witnesses that nobody saw anything. And sometimes we have very egregious crimes that are committed in front of many witnesses, and none of the witnesses want to cooperate. This makes it virtually, at times, impossible to prosecute sometimes very serious crimes. So I don't think the police are out to trap anyone that's innocent. I certainly don't believe that. I believe that when they conduct an investigation, they are actively pursuing the guilty party, and a person who is a witness to a crime, I feel, should cooperate 100%.
say you're part of a crowd of 10 people, maybe that's not a crowd, 20 people, and 2 people in the crowd, and everybody saw it because they were circled around them and were watching this fight. One pulls out a knife and stabs the other one. Now, these are the witnesses in the circle. Do you recommend that they talk to the police?
Absolutely. How else are we going to prosecute the person who stabbed the victim?
Okay.
If we have a victim and a killer, who's going to testify? If the guy's dead, he certainly can't testify. So certainly we rely on eyewitness testimony.
Mr. Brown? What's
to
the
assure
civil
if you
side of this?
No, there's no civil side. I actually just brought up a good point, which the viewers may or may not want to know, but I'd like to know, because you see it in the television and movies a lot, is when is that line crossed between not helping or not assisting and closing your mouth and what we've heard is being called obstruction of justice, because there is such a thing. And I'd like to know from your perspective what that line is.
Well, lack of cooperation with the police basically is a civil duty. When you see something occur, I mean, I think we all have a duty to make our community a better place to live. I think the way to guarantee a crime-ridden community is for people who see bad things happen and not talk about it. Refusing to cooperate with police in and of itself, just under those facts, in and of itself, is not specifically obstruction of justice. Many times, a lot of people will see something, they will tell the officer, well, I didn't see anything. I wasn't there. You know, they make a false statement. And then their conscience will catch up with them, and they'll say, okay, I was there, and I saw the guy with the knife stab the guy. Well, by then, we've already got them on record saying that they didn't see anything, so when they take the stand, they're automatically an impeachable witness.
They perjured themselves.
So, not necessarily perjury, but they've made an inconsistent statement that's going to damage their credibility. That's why I think an innocent person who witnesses a crime certainly has nothing to lose by cooperating with the police.
Well, Mr. Green, how do you address that?
Well, we're not, Bobby and I are not suggesting that if, there's 20 people in line waiting to go to see a movie, and suddenly, 18 of these people see person 19 pull out a knife and stab person 20, that they shouldn't cooperate and say what they saw. That's not at all the thrust of what we're saying. I mean, there's a difference between you being the witness to some event like that and to you perhaps having been a participant or an alleged participant in some other type of event or any type of event when the police are coming to you and saying, well, we heard that such and such occurred, and we just wanted to hear your side of it because, we don't know that you really did anything, or we may not think you did anything. We just want to get your side of it. Well, if they're coming to get your side of it, it's not good news for you. And like I said, close your mouth.
Well, now, Mr. Brown, in a civil case,
Yes,
there are witnesses too, aren't there?
absolutely.
I mean, different kinds of civil cases.
All sorts of people, and their interests vary depending
Yeah.
on the circumstances.
So there could be a contract dispute, and where one person says you didn't do these things the contract said you should have done,
Correct.
and there may be witnesses
There may be
to that
witnesses
effect,
to
right?
discussions.
Yeah.
Witnesses in those types of cases and the types of cases we handle usually revolve around who was in the room, what was discussed, what was the intent of the parties, what were the leading up to the signing of the contract, those types of discussions.
Well, how should they react when, say, a lawyer comes up to them? Your friendly lawyer comes up to them.
Well, it depends. A lot depends on whether or not, the situations that we run into a lot are people who work for companies or corporations who are, we're either suing them for a breach of contract or some other dispute, and obviously those folks are still in the employ of that corporation, and it's difficult. We get into deposition situations quite often where these people are being deposed and they are still under the employ of this corporation that you're suing. And although they're under a duty, under an oath, when they're answering these questions in a deposition, sometimes their answers are not quite as candid as you would like them to be, obviously because they are still in the employ of this situation. Sometimes you run across people who are former employees, and you get straight answers out of those people, but you don't know whether that person has a grudge with his former employer or other. So you really have to evaluate when you're doing those types of situations, especially in a civil case, people's motivations and what they're coming from. And if you're a defense attorney, the same thing. You examine those persons with a critical eye to see whether or not they do have any bias or motivation in what they're telling you. And it's usually pretty clear. After doing it quite a few times, you can usually tell whether a person is being forthright with you or whether they have something to hide, and can examine those people further in those areas in order to get the right answers.
Mr. Guttridge, we have a question about a bartender. Can a bartender be held liable for DUI with serious bodily injury? I would assume the question is the bartender that served the person who was drunk and got in an accident where there was serious injury.
Well, I mean, I guess theoretically that could happen under a certain set of circumstances. I've never seen anyone prosecuted for it. Most criminal laws require some form of intent, although DUI manslaughters and DUIs don't really. There are certain crimes that don't require an intent, where you actually want to do something, you intend to do something that would harm someone else. Certainly a bartender doesn't intend to cause the crime. In this case, it would be a DUI, I'm assuming, or a manslaughter case where someone gets hurt. They don't intend to cause that person to do that, and in fact, they're just a collateral person in the whole thing. Now, I suppose if they came in sloppy, drunk, I suppose that there could be a scenario where they could be charged if they were completely reckless and they handed them the keys and walked them to their car and patted them on the butt and said, "Hey, see you later. Go out there and get somebody." But I think it would be incredibly difficult to prosecute that kind of case, and frankly, I've never seen that happen. I've never even heard of it, and I think it would be extremely unlikely.
Let me ask Mr. Taylor, we've got a call in here, and I'd like to hear both from you and Mr. Green on the prosecution and defense side of this question. If you were with a friend who was involved in a crime, are you guilty of the crime too? Can you be arrested just for being there? Mr. Taylor.
Well, let's remove the personal. If I were with a friend who committed a crime, I think there is a thing called the principal statute. As far as jury instructions are concerned, a person under certain circumstances can be guilty of a crime even if he's not present with the friend at the scene of the crime. There's a strict set of circumstances that must apply. The person must know what's going on. He must intend for the crime to be committed. He must aid and assist the person in committing the crime, whether he's there or not. And he's called a principal. If we can meet the burden of showing that someone is in fact a principal to any crime, then that person is under the law just as guilty as the person who in fact killed the crime. Committed the crime. This happens a lot in robberies where there's a getaway driver. The getaway driver is not actually involved in going into the store, holding the gun, committing the robbery. But that person he was involved with the planning. He did anticipate a benefit from the robbery, and he did assist by giving his co-perpetrators a ride. Presence alone is not sufficient. There is other elements we have to prove.
Mr. Green. Any comments on that
Well-
from the defense side, or?
Yeah, there's,
I mean,
presence alone is not enough, but I've seen dozens and dozens and dozens of cases where the police, when they come in, and if, one person has committed an act, that's a criminal act or something, they're just going to take, if there's two of you there, they're going to take you both and sort it out later. I've seen that happen on many, many occasions.
Possession of drugs in a room in a house?
No, if the police barge in for one reason or another, and there's 4 people sitting by a couch and there's an ashtray with some marijuana in it, they're going to yank all 4 of them out and arrest them all and just let the prosecutors sort it out, or they figure what the heck, and that's what happens. And I've seen that dozens and dozens of times.
And do the state attorneys then, as Mr. Taylor indicated, they have to sort out which one, right?
Well, they're supposed to.
Possession.
They're supposed to do that.
Well, what if this marijuana's under the couch, and there are 2 on the couch and 2 in 2
Well,
chairs?
they shouldn't be arresting anyone.
Because they are arrested.
Well, of course they are, but if
Considerations.
as a prosecutor, your duty is, to be able to prove the case, and the possession, you have to have possession and control, and they're going to have to show knowledge.
Okay.
So if it's under the seat of the couch, how are they going to tell that, Mary, Jane, or Frank, that while we're sitting on the couch, A, knew it was there, B, it was theirs, and they possessed it?
That would be difficult, I agree.
Yeah.
I agree. But there is something called constructive possession as well as actual possession, and it's not quite as stringent for us to prove constructive possession. However, we do have to prove knowledge, that they knew the substance was there and they were aware of the controlled nature of the substance.
And that they had control of it.
It was in a place where they could exercise control.
So if they're under the influence of marijuana, but their hands aren't on it,
Well,
that's knowledge.
it's illegal to possess, but not illegal to smoke.
Oh, it is?
But that would tend to show knowledge, I would believe, if the
Okay.
person was under the influence, and we could prove that.
Okay. We've got one about somebody being injured on the job. If I am injured on the job, what should I do first? Will I be responsible for medical bills? Anybody want to try that one? That's a workers' comp issue. It's a little
Well,
different.
I really don't workers' comp, but I can give a general answer, and Norm can.
Yeah, generally in workers' comp, it's totally statutory, and you have to inform your employer, and if you're on the job and it's covered by comp, the bills are paid by the comp, the medical bills.
Is that your understanding?
Yes, absolutely. It is important to report it as soon as possible, and really the requirements, as I understand them, is that the injury occur either on the job or while in performance of your duties on that particular job. And sometimes it doesn't require that you actually be physically present on the job site. There are cases out there where workers' comp coverage has found to have been in place, and payments were made, in transition to your office, et cetera, so,
Okay.
or to your place of work. So there are circumstances, but it is important to report it as soon as possible.
So even if you're driving in your own car, if you're going from job site A to job site B as part of your job, you could possibly
Absolutely.
Okay.
Yes.
have coverage there.
Yes.
Okay. Got another one. Another bartender question,
Oh, good.
but it's very similar. Mr. Taylor, this business of how many cases a state attorney handles is drawing some questions here. And this one's about bounty.
Bounty?
Bounties, apparently.
Okay. So
Do the prosecutors receive monetary bonuses for convictions? Do you get paid more money if you convict people of crimes?
No. No. That's not, we
Short
have a
answer, no.
caseload. I think we get rewarded for job performance by doing a good job. And sometimes, convictions fall into that. Certainly, we don't, no, the answer is no. We don't. I think the more I talk about that, the worse it's going to get. There's no quota and there's no bounty.
Okay. Mr. Brown, there's a quick question dealing, I believe, with the corporate annual report. I forgot to mail in my annual report to the Department of State. Now I have a penalty. Do I have any options other than paying the penalties? But I need a quick answer because we only have 3 minutes.
The answer is no, or as of August, it will be administratively dissolved by the state. So if you want to keep your corporation, it will be dissolved. without that fee being paid, or you can just have it dissolved and start a whole new corporation next year.
What if you want to keep your corporation, but you don't want to pay the penalty?
Unfortunately, you don't have that option.
Okay. Pay the penalty.
Pay the penalty, keep the corporation, or let it be dissolved, or dissolve it yourself, and start a new corporation.
All right.
Can't use the same name, though.
Right.
It has to be a different name.
All right. So if you did not pay the penalty, you didn't feel like paying the penalty, so you're going to let it go. You can start another corporation, but it has to have a different name.
Correct.
Okay.
And I believe May 1st is the cutoff in the state of Florida for filing.
Okay. Well, we're getting near the end now. I'd like to, if there's anything, I'd like to have each of you take maybe 30 seconds or less. We're down to about 3 minutes. So, Mr. Guttridge, would you like to start and tell us anything you'd like to tell us about criminal defense practice that maybe would help the viewers in their daily lives?
Well, certainly if anyone, police officer or anyone from law enforcement comes to you, call a lawyer. Don't try and talk your way out of it. Don't try and do something or befriend the officer or think that you can somehow know more than a lawyer would or know your way around the law. That is the single most detrimental thing to any case. You cannot possibly know as much as a well-trained, experienced lawyer.
Okay. Mr. Brown, in the civil business?
In civil disputes, so what I've found, Russ, is that everybody has a story to tell, and we like to listen to their stories, and if there's some way we can help them or assist them in their dispute with another individual, we'd be happy to do that. And we advise that come sit down and talk to us, and if there are legal options for you, we will advise you both the good, bad, and the ugly. So if
it doesn't always involve going to court, does it?
It doesn't, no. In fact, I think there's a statistic like 97% of cases in civil litigation are settled outside of court, so no.
Mr. Taylor, what can you tell the viewing public that would be of assistance to them in their daily lives?
Well, I would just like to invite everyone to come watch us in action. This is the criminal justice system is an ongoing process. It's a public process. The courthouse is open to the public. Almost everything that goes on within the criminal justice system is open to the public. So certainly, you can listen to us talk all day, but the best action, the best way to learn about the judicial system is to actually go and see it in action. So come to the courthouse and watch us work.
Okay. Mr. Green?
Well,
Family?
family law, think before you act. Remember, no matter how aggravated you may be with your spouse, don't do anything in front of your children to demean your spouse. Don't do anything in front of your children as far as these arguments about the divorce are concerned. Try and keep the children out of it. Try and remember that no matter what happens until these children, no matter how old the children get, once you divorce, you're still going to each have that responsibility, that attachment, that bond with those children, and you need to think before you act.
Okay, well, I want to thank the viewers who called in and those who are listening. Thank you very much for participating and helping us make this part of Law Week. It's important to all of the attorneys of the Indian River County Bar that you understand what we do, what's available, and the fact that you can just come talk to a lawyer. You don't have to be involved in a lawsuit. You don't need to be involved in civil or criminal litigation. Just sometimes it's good to get the preventative medicine, the advice on what the law is and what it isn't, because so many laws are out there, and you don't even have one single lawyer that practices all the different kinds of law on a regular basis. So thank you very much for watching us tonight. We're going to take a short break. We're going to change the panel of attorneys, and we will be ready for more questions in about 5 or 10 minutes. We're going to go from 8 to 9 o'clock tonight after this short break. Thank you.